Hello, good afternoon, everybody, and thank you very much for joining our webinar. My name is Andrew Harrow. I'm Managing Director of Baxter Personnel. Unfortunately, you're going to have me for the next couple of minutes, but with some good news. Along with that is I've been delighted to say I've been joined today by Paul Clark, who is Head of Employment at Jackson's Law Firm, and Alasdair Ross, who is the CEO of We Do Group, which incorporates We Do HR, who are a HR consultancy based in Darlington. So the webinar today, we are looking at IR35, the Criminal Finance Act, and also worker exploitation and tax evasion. The format for today is I'm going to sort of go through the first part, which is going to be really sort of geared towards the Criminal Finance Act and worker exploitation. I'm then going to hand off to Paul. Paul is going to take you through IR35 employment status. And from there, Ali will speak to everybody from more general HR consideration point of view in terms of how to get your business and your recruitment strategy set right from the start in order to avoid problems moving forward. At the end of all of that, if you're still with us, we will answer the questions that you very kindly sent in earlier. If you do think of any questions as we go, please feel free to put them on the chat, which is just at the bottom of the chat window. And again, if we get time at the end, we'll go through them sort of live now. But if not, obviously we'll come back to you guys as soon as we can. Great. So I think from my side is coming from the Criminal Finance Act. I think one of the big assumptions that a lot of companies make, and I'm about to make an assumption here that everyone on the webinar is either in a labour supply chain or has a labour supply chain. And from our perspective, from the criminal finance perspective, the big assumption that people make is because they may be engaged with an agency, and that an agency is sending workers to either the site or a project or whatever, that those workers will be employed by the recruitment agency and therefore sit outside IR35 because the agency is employing them on a pay-as-you-earn basis. And this is a really big assumption that because of the Criminal Finance Act, which is essentially making you commercially culpable for that decision, is a big assumption that can get people into some serious sort of trouble. There's lots and lots of payroll schemes that are designed purely and simply to evade tax within labour supply chains. There's so many to go through that we simply don't have time today, but I'm happy to talk to anybody on a one-to-one basis about what that might look like in the different types, I beg your pardon, of tax avoidance schemes and essentially frauds that go on. But effectively, I just wanted to bring that point to the table that please don't assume because you engage an agency to supply you staff that those staff are being payrolled and engaged correctly to keep them outside of the IR35 legislation, because as I sort of said, there's almost a 50% chance that they're not. So that's exactly the point we want to sort of start to make as from Baxter Personnel's point of view, I beg your pardon, because as a recruitment agency, we've been in operation for maybe 30 or 30 years on the 26th of March. And we as a business have always payrolled our employees through pay-as-you-earn. We've never been involved in umbrella companies or anything like that. So why I'm telling you this is because we are able to give you our professional advice over a 30-year period. So when you're looking at your labour supply chains, which you are now are going to have to because of IR35, if you haven't already, then I would suggest you do it very quickly. Say it was going at a rapid rate of knots. But I digress. The experience that we can show you, we can delve into your labour supply chains and basically give you the red flags, what you need to be looking for. What constitutes, do I need to look at this further, and what compliant payroll process looks like and what a non-compliant payroll process looks like, which is exactly the experience that we would sort of like to offer in terms of your labour supply chain. So moving it on from there a little bit if I can, Paul is going to now get into IR35 and employment status within that, because the bit that we can sort of look at for you isn't necessarily determining whether somebody is in or out of IR35. We can particularly help you with the tax avoidance and the umbrella schemes and all other things that go on in like the supply chain, where you potentially assumed it's been fine when in fact it isn't. But in terms of the actual employment status definition, how you arrive at that once you've audited your supply chain, then that's where Paul will be able to come in and help you a lot better with that. So I'll hand it over to Paul.
Great, thank you, Andrew. I'm just going to share my screen because I've got some slides which hopefully help take us through this. So you'll just bear with me. Started at the end, right at the beginning. There we go. Hopefully everyone can see that okay. Yes, I'm going to talk about employment status and IR35. I'm head of employment at Jackson's law firm. And IR35 does fall within the remit of employment law because a lot of the tests for determining status are the same between employment law for the purpose of the IR35 tax legislation. So IR35, the legislation's been around since the millennium. The name is derived from the 35th tax release by the Inland Revenue, which was what HMRC was known back then, and that was back in 1999. And the purpose behind the legislation effectively is to tackle disguised employment. So where somebody's a contractor but avoids payroll by being engaged through an intermediary. And that's in circumstances where if they were directly contracted, then they would be regarded as an employee for tax purposes. HMRC thinks that the unpaid tax and national insurance through disguised employment will cost the Treasury £1 billion in lost revenue by 2022 to 2023. So in the current, climate, you can see why they're keen to press ahead with these reforms. At the heart of IR35 is the hypothetical or notional contract between the worker and the end client, and it's that relationship which really falls under the spotlight. Certainly, assessing IR35 can be quite complex, but it gets a little bit more complicated where you've got a worker who's engaged in a series of intermediaries, so there's a long contractual chain. It's a lot easier where you've just got the one intermediary. So to give you an example, if there's a client who engages John Smith through John Smith's personal service company, John Smith Limited, then you've got the client, John Smith Limited, and John Smith. The analysis there would be the relationship, the hypothetical contract between John Smith and the client. So effectively ignoring John Smith Limited. If John Smith provides his services to the client through John Smith Limited, and John Smith Limited is itself engaged by an intermediary, so an agency, let's say, then obviously there's another person in the chain there, and that has an impact in terms of some of the responsibilities. Now, the changes which are coming into force on the 6th of April are going to alter the responsibilities within the contractual chain. But effectively, and the intention is that everyone in the chain will have some involvement, even if it's just relaying information down the chain. And also, it's important to remember that IR35 is going to apply on an engagement by engagement basis. So it's not just, it's not just covering contractors who are engaged for months or possibly years on one particular contract. Someone's engaged through an intermediary on a series of short-term contracts, then IR35 is going to need to be considered each time, and the status determinations and the status determination statements, which I'll come on to explain, will need to be supplied each time as well. What happens if IR35 applies, if you're caught by IR35? Well, there's something called a deemed calculation. The fee payer, now that might be the end client in the example I gave with John Smith Limited and the end client, or if it's a longer contractual chain, it'll be the intermediary in the contractual chain, which is closest to the worker's intermediary, so the agency in the example I gave before. Well, that organisation will need to operate pay as you earn on the payments to the worker's intermediary, to John Smith Limited. And that would mean that obviously John Smith receives less pay because there's going to be tax and national insurance deducted higher up the chain. Now, there's a number of first-tier tax tribunal cases which are out there. Certainly, they're increasing in recent years. I've referred just to one of the judgments there, Red, White and Green Limited versus HMRC. And this is a finding in relation to services provided by Eamon Holmes to ITV via his limited company, Red, White and Green Limited. Contrast this with an earlier finding, because in that case, Eamon Holmes was found to be providing personal service to ITV, and therefore he was caught by IR35. Contrast that with an earlier finding in relation to Lorraine Kelly, who was providing services via her personal service company or her limited company, Albertel. And a couple of years earlier, she wasn't caught by IR35, which really shows that similar cases can produce some very different outcomes. And these cases are always very fact dependent. Now, IR35 is tax legislation. It operates to determine status for tax purposes. It doesn't confer employment rights. So if you're caught by IR35 and you're taxed as an employee, doesn't mean that you'll have employee rights. However, HMRC and the first tier tax tribunals take a similar approach to determining status as employment tribunals. The same decisions are going to apply to both, notwithstanding that because of the dichotomy, you might have someone who's, let's say, employed for tax purposes, but a worker for employment status. And this brings on to another difference. There are 3 different statuses in employment law: employee, worker, self-employed, and only 2 for tax purposes. You're either employed or you're self-employed. Now, the ready mixed concrete case there is a 1968 case. It goes back a long time, but it's probably the seminal case for IR35, as it sets out the conditions for employment, so that it's most relevant to your IR35 determinations. 4 conditions there: personal service. Someone must be providing personal service. They've got to do the work themselves or provide the service themselves to the end client or to their employer. Mutuality of obligation. That effectively means it's a dual obligation. The obligation on the employer to provide the work and pay, and the obligation on the employee to perform that work for the pay, often referred to as irreducible minimum of employment. Third condition is control. The employer effectively must direct how the work's being done. If someone has control over how they do the work, if, for instance, an organisation engages someone to build a hospital or some of the building, and basically said, just get on with it, you do it how you want, then the likelihood is that's not really employment. That's more likely to be hinting towards self-employment. However, if actually they're engaging someone to do work within the building of that hospital, then that's be more of an example of employment. And then also the 4th condition, which is quite wide, is that there need to be conditions. The other terms are not inconsistent with an employment contract. So if someone's being paid regularly, so monthly, let's say, if they don't have, they don't bear any of the risk in relation to the work. So if something goes wrong, they don't, the pay's not docked, or if they don't have to fix it on their own time. If the employer provides them with tools and equipment, that might be more of an indication that someone's employed. If the employer or the business insists that they only work for them, so if there's exclusivity, that's something which is not inconsistent with an employment contract. Equally, if they're given benefits, the benefit of sick pay, for instance, or holiday pay, then that's another indicator. And there might be other factors which makes them part and parcel of the business, to use a term. So someone who's involved or is given training alongside other employees, or even invited to the Christmas party, or given access to confidential information which other employees receive, well, that's all sort of indicators that they're probably employed too. As I've said, worker is a separate concept. It's an employment law concept, but some of the decisions in worker cases are relevant for IR35. So have a quick look at those. I've just put on that slide here, and we'll share the slides after the webinar today, but just an example of the different rights that employees, workers and self-employed contractors have. So you can see that employees have the full panoply of employment rights, self-employed contractors don't, and workers have a mix of some. So the first case there, Autoglens versus Belcher, is probably the most important or pertinent worker case as far as IR35 is concerned. In this case, the Supreme Court found that a written contract between 2 parties, or between someone who's described as a self-employed contractor and a business, may have terms that haven't been agreed. There might be terms which the engaged or the employer insisted on, and they might not actually reflect what happens in practice. And the Supreme Court said in those circumstances, courts and tribunals should look beyond the written terms of the contract to look really at what the reality of the relationship is, what's happening on the ground or in practice. Now, Autocleanser Belgium was mentioned recently in these two cases. The first one, you may have heard of the Pimlico Plumbers judgment that's been in the press in recent years. In that case, the Supreme Court did exactly what the guidance in Autocleanser Belgium indicated, and they looked beyond the written terms of Mr. Smith's contract, because Mr. Smith's contract with Pimlico said that he could provide a substitute. And of course, that negates personal service and indicates that maybe he was self-employed. But in reality, the substitute that Mr. Smith could provide to Pimlico Plumbers had to be another plumber with Pimlico Plumbers. And that meant it was a very fettered right of substitution. So in reality, he ended up providing personal service. That was one of the reasons why he was found to be a worker as opposed to a self-employed contractor. And the second case, you probably heard this last week, the Supreme Court released its judgment in the third appeal by Uber in relation to their drivers having worker status. And the Supreme Court said in that judgment that the contractual terms themselves, written contractual terms, not the starting point for determining status. And in that case, Uber was saying, well, the agreements we have with the drivers effectively mean that we're acting as an agency and they're all self-employed. But the Supreme Court and the previous appellate courts have been happy to look beyond those. And in reality, because the drivers, when they're on the app, they have to do work for Uber, they can't really work for anyone else. That was one of the factors which led to the Supreme Court, in this case, deciding that they were workers and as opposed to self-employed. And those cases really also indicate as well, I think, the importance of updating terms, because when you're doing your IR35 determinations, if what's in paper doesn't reflect the reality of the relationship, then it obviously makes sense to update those written terms so that it does going forward. So a recap, where does IR35 apply? Well, you've got an individual who personally performs work for an end client. There's no direct contract between worker and end client because they're engaged via an intermediary. The end client is either a public sector authority or it's a medium or large private sector entity. I'll come on to explain that in a moment. And the circumstances are such that if there was a direct contract, if there was a hypothetical or applied a hypothetical contract between the individual and the end client, that if you looked at that, the individual would be regarded as an employee. So those are really the four conditions. What's happening from the 6th of April? Well, in the private sector, there's going to be a shift in responsibility up the contractual chain for determining whether IR35 applies. And it's going to fall on the end client to have to carry out these determinations. And that reflects really a change which came into the public sector back in 2017. Now, there's a small business exemption. So small businesses are exempt from forthcoming changes. In those cases, in the case of small businesses, responsibility for determining IR35 will remain with the intermediary. So the first question for any end client to ask is, am I a small business? Well, small businesses have, if they've two of these three conditions, if they fulfill two of these three conditions, they'll be a small business. So if they have a turnover which is less than 10.2 million, they've got less than 5.1 million assets on the balance sheet, or if they've got less or equal to 50 employees. If two of those three conditions are fulfilled, however, then you won't be a small business and you won't be able to rely on that exemption. And just remember that businesses obviously change over time. So an organisation which is a small business now might not be in the future. So it's really important that everyone gets an understanding, at least, about IR35, even if you are a small business at this stage. And what's the effect on liability? Well, because the end client is responsible for carrying out these status determinations, the end client must give the party that it contracts with, so in the simple John Smith chain, John Smith Limited, or in the more complex chain, the agency which engaged in John Smith Limited, it must give them a status determination statement. Now, there's no prescribed form for that, but effectively it's going to be a letter or other document which sets out why the end client has determined that either IR35 applies or doesn't, and some explanations as to why that is the case. And they've also got to give that status determination statement to the end worker as well, to Social John Smith. It's going to apply to all new and existing engagements from the 6th of April. And until that status determination statement is issued, the end client remains on the hook for any tax and national insurance if IR35 applies, or if HMRC investigate and decide that HMR does apply, that IR35 does apply to the relationship. So it's important to obviously do the status determination statements. Another thing which is going to come in force is that the end client's got to take reasonable care when it's carrying out their status determinations and also notifying the relevant parties. If it doesn't take reasonable care, I'll come on to look at this in a minute, then again, it will remain on the hook for unpaid tax and national insurance. However, if the end client does take reasonable care and it decides that IR35 applies and issues the status determination statement, then it or the fee payer, if there is one, makes a deduction of tax and national insurance, then that will obviously happen, and the intermediary engaging the worker will receive a lower charge. So what amounts to taking reasonable care? Well, this will really depend on the end client circumstances, but effectively, large companies are going to have, there'll be higher expectations on them. So HMRC wants to see you doing more to carry out determinations and make sure those are correct if you're a bigger organisation. HMRC have given some indicators of the sort of behaviours they want to see, and these are quite long, quite onerous. They want businesses carrying out determinations to be aware of and understand the conditions for employment, because they want you to apply the employment status principles. So they want you to have some knowledge about how these determinations work. They want you to use the government's test or check employment status tool, which is a tool you can use to fill in details, and it'll give you an indicator of whether someone's caught by IR35 or not. But obviously, it's only as good as the information you put in, and it's not infallible in any case. So the third one, which is also important, is that HMRC wants organisations carrying out determinations to take professional advice. The CES tool isn't going to be enough. They want you to go and seek advice from someone who understands the process. They want you to review status determinations, particularly if there's a change in working practices. They want you to keep these determinations under review. And they also want you to check the processes in the contractual chain, take some responsibility for how the information is being passed on, so that everyone in the contractual chain is aware. Now, last week, HMRC announced that they're unlikely to be issuing fines for non-compliance in year one, which obviously is a good thing. I think there's exceptions there that it's a difficult time to be doing this coming off the back or at the end of, hopefully the end of the coronavirus pandemic. However, even though there might not be fines, responsibility is still going to remain with the end client. And if they're not fulfilling their obligations, then there's a risk of potential bills for unpaid tax and national insurance. So you might not get fined, but you might find that you've got a tax bill. So how can we recommend that people prepare? Well, if you're an end client, then the first thing obviously is to start reviewing your engagements if you haven't already, so that you can take reasonable care, and then you can issue these status determination statements comfortably before the 6th of April. So not a lot of time left. It's also really important that you implement an appeals process, because it's got to be the right for someone who's determined, if you've determined that they're caught by IR35, for them to appeal against that. And that is likely to involve looking externally for someone to carry out a review of the determinations that you've made. Now, appeals can't start until after the 6th of April, but when they do start, they must be handled within 45 days, which means there's a fairly tight time pressure there. And failure to hold an appeal, well, that'll mean that the end client remains on the hook for tax and national insurance. So obviously it's essential then to conduct the appeals timely and consistently. And then potentially also consider changing contractual terms where you've done the determination and you find that someone is caught by IR35, if there's a different way that you can work, which may be able to take them outside of IR35. So for instance, if you wouldn't have a difficulty in allowing someone to start using a substitute, providing a substitute if they can't do the work, well then that'll be a way that the relationship going forward may not need to be caught by IR35. So there's practical things you can do as well. For contractors, well, you're obviously going to be told at some point that the end client either finds that you're caught by IR35 or not. So what you need to do if you're caught by IR35 and you want to challenge it is obviously gather the evidence that you've got which indicates that you're not an employee for tax purposes. So examples you've got of when you've used a substitute, or the control that you carry out over the work, and those sort of factors. But it's also really important that if you disagree with the determination, that you submit an appeal. And what's also relevant here is that employers are able to carry out group determination. So if there's a lot of people who've got the same terms and conditions and in practice do the same thing, then it's fair enough for the end client to carry out a determination of that group. But remember, we're not just talking about the written terms here, we're talking about what happens in practice. So if you've got a lot of people within a group who might own the same written terms, but those terms are old, or they've, in the reality of the relationship, people do different things, then there's a risk there that the employer is carrying out a blanket approach, which isn't taking reasonable care. So if you're just told by the company engaging you that everyone's caught by IR35, and in reality a lot of people are caught by that who do different things, well, that might be a reason why you want to challenge the determination. And the final slide there, I've just got some links to other sources of guidance. We've got a page on our website about IR35. There's also an article there which I've written about it. And then the third link really is to the government guidance, which is on gov.uk, and it is really helpful. So have a look at those. Do get in touch with me if you've got any questions about any of this, or if you need assistance with carrying out determinations or any appeal procedure. We'd certainly be more than happy to help. So that's a whistle-stop tour of IR35. I hope that's been helpful, and I'll pass on to Alasdair. Thank you.
Okay. Right, thank you very much. Just continue, just get my slides up, just hang on 2 ticks. Right, okay, so let's just run through some of this now. Thank you very much to Andy and Paul for that. I think it's given us a bit of food for thought to start with, which is quite important for us to start thinking about where we're up to. So let's have a look at the HR side of things. So this is a slightly different perspective, because this is about practicality. I mean, HR, let's be honest, it's often marginalized, but if you do it properly, it can make such a difference. And let's be honest, we want to get greater effectiveness in our business and greater profitability. So why not get it right to start with, rather than have to fix something later? It will definitely cost you more time and money at a later date. So don't just think about HR either as just an admin process. It's not. It's about strategy. It's about getting the right people. So recruit them right, whether they're full-time, part-time, temporary, or contractors, get them right. So using somebody like Andy, who's going to make sure that you're right at the start, getting the right people in your business, especially for your temporary workers, is a great way to go. And making it, make sure you've got a reputable company. And Paul, thank you very much. Absolutely. Get your paperwork in order. Make sure you've got good HR and good lawyers there supporting you in the background. There's a great phrase, which is always make sure that your devil's in the details, so make sure the documents are correct. And then just as a general, which is where my passion comes from with HR, is thinking about making sure that you're an employer of choice. If you want to attract the best talent, and if we think about the way the world is now, we want to be getting the best talent working for us. Who is it that you really like to be working for you? So just have a bit think about those sorts of things. So if we muse on, let's go for the self-employed workers. It's the question we want to ask, the elephant in the room. Why bother? Why bother? Why don't we just employ everybody right from day one? Well, just employing people isn't necessarily the best thing for the business. Sometimes we need to have self-employed people. They're not employees. They might be workers, but they're not necessarily employees. We can get a flexible workforce. It's usually easy, especially if we've got a transient environment, maybe in hospitality or in manufacturing, and we have spurts of work coming through, and we need to have more employees or more workers at a short period of time. Taking them on as employees creates a whole different level of admin and workload that sits behind it. Self-employed people, they're excellent for project work, ideal for short-term periods as well. And of course, you don't think that HR needs to bother itself. Well, might have less involvement, but they still need to have some involvement to make sure your business is ticking over correctly. So let's save time and money. And I'm sure you all agree with that. We all want to save our time and we all want to save money. So if we just employ self-employed people, we don't need to bother taking tax off at source. Although, as Paul pointed out, there's a few little wrinkles in there which might cause you a problem. So it might make the contractor happy. And if they're being clever and have a good accountant, they might actually be reducing their corporation tax liability. But this is one of the reasons why HMRC is getting itself focused a bit more on IR35. You know, so that avoidance, this tax avoidance issue is the biggie that's coming through, and these changes are here. So they want to make sure that you're doing the right thing. The advantage in not having HR resource being used up in your business, you've got no performance reviews, no disciplinaries, no grievances, nothing you need to worry about there. So that's excellent. So I can just get rid of them as easy as I took them on. But again, you've got to think about how they're going to fit within your strategic role. You know, think about it at board level. Have you got the right people in the right place to do the right work at the right time? And then, you know, the other advantage from a finance director perspective is obviously making sure that the contractor sits there as a variable cost. So that actually might benefit you when you're doing your year end as to how you manage your finances. So there's lots of benefits to having subcontractors, and they're a very relevant role within businesses and very necessary at the right time. But as if you've probably understood, not only are you at risk from the Corporate Finance Act, you've got the whole issues of ending up in a very costly court case trying to defend yourself and say that your people who are working for you are actually contractors when they're not, and then the invariable tax liability bill that's going to come your way afterwards. So it's quite important to tie the three together. It's why, as a tripartite arrangement, this is how we're working so well together to make sure that we're helping anybody who needs that help to get it right and get it right to start with. So what are the benefits? Well, let's have a look at those. Again, this is about cost saving as well. Termination's easy. Buy, easy come, easy go. Not necessarily right for your business. There's no post-termination redundancy, holiday, sick pay, pension, any of those costs. You don't need to worry about any of those. Not going to get an unfair dismissal claim because they're not employees, so they don't have that as a right, as Paul was picking up on. But IR35 is not about the risk of going to an employment tribunal or not. It's about the impact to you having issues within your supply chain where you might actually have a tax liability. So we need to make sure that we're getting things right. And we need to make sure that we get a robust, what's called a contract for services agreement in place. And Paul touched on these, the different elements of IR35 that talk about substitution, control, the person using their own tools and machinery, that they're able to come and work for you. So that really needs to be looked into. And the other thing I don't think Paul mentioned was about whether or not that person's in gainful employment is the expression they use. So if we think about what is it that they're doing, I have a very simple rule of thumb. If you got Joe Public to come in off the street and look at somebody who's working for you, would they actually look at that and go, I think he's working like an employee? So at the lowest level, that's the first thing you need to probably do. And then you need to start looking at the SDSs and going through those in the discretion and making sure you've got the right people in place under the right agreement with you. So these are the downsides. The shift of obligation and responsibility. You know, we had this in the public sector. There was a whole load of people left the public sector as contractors and started working in the private sector. You know, now people are, you know, you can run, but you can't hide. But the company, and Paul's giving you an overview as to the type of companies that are going to get caught by this, is to sort this out and make sure that from 6th of April that you're on the case and you know that you've got the right people in place. Now, in reality, that's going to be HR. If you think about in your organization, it's probably going to be whoever you've got dealing with your HR, whether that's an individual HR, an external HR, or your FD who happens to do it as well. And it's going to bring a load of administration. And the worst one, and Paul talked about this, which is, what if you think that everything's correct and you have somebody who's got their own limited company, they're working for you, they appear to be a contractor, but they actually work out to be employed? And this is the point about making sure that your documentation and what the worker is actually doing, the contractor is actually doing, matches. Because you can very easily fall into the wrong situation. So CEST, which is the checking employment status for tax, which is on the Gov.uk site, and if you go onto the link that Paul left there, you should be able to find that. It's a good way of covering it off and getting a rough idea of whether the people working for you fall into or out of IR35. It isn't a perfect tool. Okay, but it's a good start, and HMRC did indicate they'd respect the decision, but as Paul said, you still need to make sure the rest of it's in place. Now, the other biggie, which is the thing that's probably going to cause more problem than enough, is you're going to have resistance from the contractor, because they're going to say, I'm not employed, because they want to make sure they have control of their own finances. They want to be invoicing when they want to have freedom, they want to be able to make sure that they can put in their travel to and from the place where they happen to be carrying out the work, putting that through on their expenses and things like that. So, you know, we need to be looking at that. And then finally, if the contractor now has to pay tax and national insurance, you could end up with an increase in their chargeable costs to the business. So there's a lot to be thinking about here, a lot that comes together, and what we have to consider how it's going to have an impact on your organisation. So just to consider things, just to finalise, and we're not going to labour the point, the easiest way is to, you know, you'll have our contact details. Please contact us. Please have those conversations with us. We'll be more than happy to help you wherever we can. So the new IR35 applies to all public sector and any of the medium and large employers. So we've heard that from Paul about what they are. So no more than 50 employees, turnover not increasing 10.2 million, balance sheet assets no more than 5.1 million. So, and I think this is the bit that's going to catch a few people out. Paul indicated about as your business grows, which is great, and it goes over the threshold. But actually, if you're not ahead of the curve now, even as a small business, you may find that you've got people doing work in your business that appear to be a contractor, and you are sleepwalking into them because they're actually working for you as an employee. So I think we need to do that. We need to do that. Bonus, of course, HMRC, they won't apply penalties, but they will be watching. So I think that's important for us to really realise what we're doing. So just to say thank you very much. I hope that's just given you a little bit of a flavour of the issues that are coming. We're going to stay on and be available to answer any questions. So we'd love to hear from you if you've got something you want to ask us. Thank you very much.
Ali, Paul, absolutely fantastic. Thank you very much for that. Everybody watching, I hope you got a lot from that. As I can see, as we've been going through, there's been plenty of questions coming through on the chat. So again, as I said at the start, guys, we don't get to answer all of these because we've had a few come in prior to us chatting. If we don't get to them, we absolutely will come back to everyone as quickly as we can. So just on a couple of questions that we've already received, I've got a question here that's been sent in, and I think probably the best person for this would be Paul. Will IR35 apply to a work supplied by an agency or an umbrella company?
Potentially. It depends whether the agency is engaging the contractor through an intermediary, because this is intermediaries legislation, and it's about avoiding or reducing or avoiding disguised employment where someone's engaged through a third party. So yes, it will apply if you've got the agency engaging John Smith through John Smith Limited. But if the agency is actually employing John Smith and you're going to work elsewhere, well, no, there won't be any double recovery. There won't be hit twice for tax in those purposes, because obviously if John Smith's employed by the agency, then he'll be paying tax and national insurance on his earnings. So yeah, potentially it does, but again, it will come down to the circumstances of the engagement and the contract.
Oh, perfect, great, thank you. I can just actually see on one of the slides questions, I beg your pardon, someone's asking if we can email the slides out. I think guys, I think both they're available to be emailed out.
Yeah, more than happy. Yeah.
Yeah, great stuff. I'll run up to another question that we've had sent prior. This one's actually for me, and the person is asking, when we're looking in our labour supply chain, what is it I'm looking for? So as I said right at the start, there's two things to this really. One is the IR35 piece that Paul's obviously taken us through in detail, but there's a tax avoidance piece that I touched on briefly as well, which is where the Criminal Finance Act comes in. And if I can answer that purely from an agency's point of view and helping you identify tax avoidance or tax fraud in your labour supply chains that you've assumed isn't there because you're using an agency, there's a couple of early triggers that you really sort of ought to be looking at, and I can go on and on and on, and you can answer this until you end up looking at people's bank accounts. But there's a couple of triggers, as I say, a couple of flags that you really should be aware of. And I think the first couple really is, if you use an agency such as Baxter Personnel or any others, ask to see the contract between the agency that you are engaged with. So if you have a contract with Baxter Personnel, let's say Baxter Personnel on it, so your contract is with us, not a company you've not heard of. If the other thing to look out for is the contract that exists between, and this does certainly tick an IR35 box, is the contract between the worker and the agency. So have you got candidate A's name on a contract, and have you got the agency that you believe you're engaged with? Are both of those people on that piece of paper? Because quite often when there's tax avoidance and fraud going on, the workers are actually employed unbeknown to the end user, to the client, which is again where our assumptions come in. They're actually employed elsewhere. And these are the kind of flags and triggers that we need to be sort of looking at. The other thing as well, just to take that a little bit step further, is actually do some auditing on people's, by people's and candidates' pay slips. So once you've seen the contract and satisfied yourself with that, is the pay slips that these guys are receiving, are they pay-as-you-earn pay slips for a start? Is the people who are paying the agency worker, is that the agency that you're engaged with? And start to join up and create this paper trail, so you can at least satisfy yourself with the reasonable measures that Paul mentioned earlier on. But if you're starting to get bumping into different names, certainly from companies' perspective on contracts and pay slips, then as a company, Baxter Personnel can help you start to ask some deeper questions as to why that might be and where that can potentially lead. As I say, I could go on for an hour in terms of how deep in that audit you can go, but just on a sort of surface level, make sure that your contract is actually with the agency that you're talking to, and that the worker's contract is also with that agency that you're talking to, and then pay slips are again with the worker is being paid by the agency that you're dealing with, and not the by company that you're not good to. And beyond that, as I say, we can help you if you start to come across this stuff. Give us a call or drop us an email, and we can sort of help you down a little bit further into that. So thank you very much for that question. Actually anonymous, I'm not entirely sure who wrote that, but thank you. And I think we've got time for one more. This one, in the interest of fairness, Alasdair, I've got one for you as well. As I said, guys, in any of the questions that have come through, we will get back to them. But Ali, if you could finish us off with this one. We've been asked, what are the main differences between a contract for services and an employment contract?
Yeah, okay, well, that's an easy one to start with. If you think about your traditional contract of employment or your statement of terms and conditions, it details things like who the employer is, so it's got that in much the same way. They're great similarities, but it covers off your start date, what's called a continuous period of employment. So sometimes people get stupid across or moved over from one company to another when another company's bought out. It should also have that date in there. Quite critical, because we're looking for, as an employee, they get protected rights at certain times. So we want to know when they very first started working for that legal entity. It has things like the obligations they're under, so it may have a job description, at least reference to one. It will tend to have their pay, when they get paid, how they're getting paid, if there's overtime, is that enhanced, what their holiday entitlement is. More recently, things like furlough clauses and layoff clauses, because you know, we've had a difficult year. So some businesses are starting to put those into their contracts. It will probably have some reference to disciplinary grievance and other policies, although they will tend to be referenced, or they should be referenced rather than being within the body of the process. And the other benefits that people are entitled to, so pensions, sick pay, is it company sick pay or statutory sick pay, holiday entitlement, those sorts of things. So it's got the very material aspects of what you would expect to see within within an employment contract. And just for clarity, that's a day one right as of last year, April last year. So it used to be a couple of months you used to have to get those contracts of employment out to people, statement of terms. Now it's a day one right. So you need to be ahead of the curve on that. A contract for services, however, where you've got a self-employed organisation or a company that's working with you, it's a difference. You're talking about a terms of service that's being done. And the key thing behind the contract of services, which is where you may be taking an individual who's going to do a short piece of work for you, it's about emphasising the things that Paul was talking about, that IR35 talks about. So right of substitution, the liability that they would take on board. So an easy way to think about it is if you engage a decorator to come and do some work in your house and they mess the job up, who's responsible for fixing it at whose cost? So that means that there's a liability on that individual to fix that. Obviously, it has the date of the term of the arrangement that's going to be done. So you want people to know that it's a short-term piece of work. It's a 2-month project. Let's say it's somebody who's building a dam, but again, the danger there is that somebody on a longer project could fall into being an employee by what they're doing. So it just emphasizes the differences in relation to them being, you know, have they got insurance, liability insurance? Do they have a methodology of invoicing you? And it just details things in a different way. So they are two very different documents. When you sit and look at them side by side, they're very clearly different documents. But the main thing is it's removing control, start time, finish time, those sorts of things, because they're the things that you have as an employer, that if somebody doesn't abide by them, you can take them down a disciplinary route, for example, or at least chastise them. That's probably the easiest way to answer.
Perfect. Ideal. Thank you very much. Guys, thank you very much, everybody who's attended. Unfortunately, our time is up. I'd like to especially thank Paul and Alasdair for giving up their very sort of valuable time to sort of help us all get up to speed with the upcoming legislation. In terms, just quickly going back to the questions, we'll come back to any questions that have gone unanswered. And I just like to thank you again and wish everybody staying safe and speak soon. And thank you very much.
Thank you.
Thanks, everyone.